name is Lauren Livermore, and it is my honor and privilege to serve as NYWEA's president. I'm excited to kick off this two-part series on the constitutional amendment giving people the right to clean air and water. Later this year, all registered New Yorkers will be asked to vote on this important issue. Today, we have two speakers that will make the case for all of us to vote yes in November. On May 12th, we will feature speakers who will support voting no on the amendment. Several key NYWEA members have posed the same questions to all of the speakers. Our plan is to create a white paper after both webinars and circulate that to our members so that everyone can cast an informed vote. Many thanks to Libby Ford and Sarah Loby of Nixon Peabody for developing this idea and making the connection with today's speakers. I'd also like to recognize the NYWEA panelists, Pamela Ilardo from the New York City DEP and Libby Ford from Nixon Peabody. Many thanks to Sarah Loby for serving as moderator for these webinars, as well as Patricia, of course, and Madison Quinn for all of your help. Our sincere apologies, contact hours are not being offered for this webinar today. Since this is being held as a webinar format, please feel free to use the Q&A section, which will be monitored for any questions. With that, it is my pleasure to introduce today's speakers. First, we have Maya van Rossum, and she has served as the Delaware Riverkeeper and leader of the Delaware Riverkeeper Network since 1994. Maya is also the founder of the National Green Amendment Movement. In her role at the Delaware Riverkeeper, Maya has dedicated her life to being the voice of the Delaware River. She has taken on industry, government, and even the U.S. Army, preventing harm to the river, communities, and environments she bravely champions. Now, Maya is working to empower individuals across the nation to stand up for their environmental rights by pioneering the Green Amendment movement. In 2013, Maya and her organization achieved a major victory in the landmark case, Robinson Township, Delaware Riverkeeper Network et al. Versus the Commonwealth of Pennsylvania. The case, decided by the Pennsylvania Supreme Court, revived the state's long-ignored constitutional environmental rights amendment, empowering it to protect the people's right to pure water, clean air, and a healthy environment. The Green Amendment movement is inspiring communities across the nation to secure their own constitutional right to a healthy environment by pursuing green amendments in every state constitution and ultimately at the federal level. Maya is a licensed attorney in 3 states, including Pennsylvania, New Jersey, and the District of Columbia. And since 2002, Maya has served as an adjunct professor and director of the Environmental Law Clinic, which she founded at Temple Beasley School of Law. Our second speaker will be Katrina Kuh, who joined the Pace University Elizabeth Haub School of Law faculty as the Haub Distinguished Professor of Environmental Law in 2017. She was previously on the faculty at the Maurice A. Dean School of Law at Hofstra University, where she was a professor of law and served as the Associate Dean of Intellectual Life. Professor Kuh's scholarship focuses on climate change and sustainability, and she has taught environmental law, international environmental law, global climate change, and U.S. law, administrative law, and torts, quite a few. She is the co-editor of the Law of Adaptation to Climate Change, United States and International Aspects. Before entering academia, Professor Kuh worked in the environmental and litigation practice groups of the New York office of Arnold and Porter LLP and served as an advisor on the natural resource policy in the United States Senate. She received her undergraduate and law degrees from Yale and served as a law clerk to Judge Charles S. Haight of the District Court for the Southern District of New York and Judge Diana Gribben-Matz of the U.S. Court of Appeals for the Fourth Circuit. So with that, Maya, take it away.
Sorry, have to find that mute button. We all know that. We all have to find where that mute button went. And now I'm going to do a screen share. So we'll get that going. And let me make sure I'm starting from the beginning. Fantastic. So I really appreciate that very kind introduction, and I really appreciate the opportunity to speak with you here at NYWEA about what I think is a very important opportunity for environmental protection. You had a great introduction of myself and of Katie, and so I won't spend time on that. But I do just really want to jump into, why are we here talking about advancing another pathway, a new pathway for environmental protection in the state of New York? And why am I looking to advance this concept in other states across the nation? And the fact of the matter is, whether we're talking about New York or any state, we have people who are drinking contaminated water and people who are breathing contaminated air. We have people who are being forced to live next to highly toxic sites. We have species of all kinds that are being impacted because of pollution and degradation, and sometimes in very serious ways. And of course, we're facing a climate crisis. And so as a result, just by looking at what's happening on the ground, we can see that here in New York and beyond, there really is something missing when it comes to environmental protection. The laws are not fully meeting the need of the environment and of the people to protect our water resources, our air, our natural resources, and of course, ensuring a livable climate now and into the future. Katie's going to delve a little bit more into the whys on that front here in the state of New York, but I really just wanted to touch on that and really recognize. And of course, environmental justice is a critical issue here in the state of New York and beyond, with communities of color and low-income communities, Native American communities, being disproportionately burdened by pollution and degradation because of how and why and the way in which New York laws, federal laws, and laws across the nation are interpreted and implemented. So there is truly something missing. We do need an additional path to help us fill those gaps and address those inequities. And here in the state of New York, we wonderfully have an opportunity to help address that gap by raising up environmental rights into the Bill of Rights section of the state constitution, so they can be constitutionally and legally protected in the same way we constitutionally and legally protect those other fundamental rights we hold dear, the rights that are critical to ensuring safe, secure, happy, healthy lives here in the United States of America, here in the state of New York. What I call a Green Amendment, the Green Amendment proposal, there actually is a definition for a Green Amendment. I can talk about that later, but the New York Green Amendment proposal proposes to add to the New York State Constitution a section, into the Bill of Rights section of the Constitution, a section 19, which would read that each person shall have a right to clean air and water and a healthful environment. Very simple, very direct, but very important for recognizing the fundamental, inalienable human and natural right to clean water, clean air, and healthy environments. This amendment has gone through the legislative process, and it's actually been passed by the New York State Legislature twice in 2 consecutive legislative sessions as required by the Constitution. And so next stop is going to be the people of New York. And we all in New York are going to have the opportunity to decide whether or not we, the people, would like to see our Constitution amended to recognize and protect environmental rights. Now, at this point, there are only 2 states, but there are 2 states that raise up environmental rights in the same way that we're talking about doing here in the state of New York. In other words, they recognize and protect fundamental environmental rights in the Bill of Rights section of the state constitution in a way that is self-executing and ensures that those rights are legally and constitutionally interpreted and protected in the same way we legally and constitutionally protect those other fundamental rights we hold dear. Things like the right to free speech, freedom of religion, private property rights, and more. One of the questions that has been put forth that we understand people have is, how does New York's proposed amendment compare to other states? And seeing as there are only 2 other states that raise up environmental rights in the same way, I'm just going to share with you the language from those 2 states. One is the Commonwealth of Pennsylvania, in which it's a little bit longer, but it promises that the people will have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment, and ensures that Pennsylvania's public natural resources are the common property of all the people, including generations yet to come, and that the state has to serve as a trustee of these resources and conserve and maintain them for the benefit of all people. Montana is the other state, and actually in the Declaration of Rights section of the state of Montana, you have fewer words, just like are being proposed here in the state of New York. In Article 2, Declaration of Rights section 3, it talks about all persons being born free and having certain inalienable rights, and those rights including the right to a clean and healthful environment. There's then additional language lower down in the Constitution in Article 9, Section 1, which talks more fully about the environment and about environmental rights, and the way these two constitutional provisions have been interpreted by the courts in Montana. Really, the Article 2, Section 3 sort of bootstraps up the additional language that's found lower in the Constitution. But what is in the Bill of Rights is pretty short, clear, and direct, which is what is being talked about or what is being proposed here in the state of New York. Again, that each person shall have a right to clean air, water, and a healthful environment. I do want to note, well, I'll note that later. So you can see, though, there are differences, but there are also some strong comparisons between these three. The most important of which is they're very direct about the kinds of environmental elements that are being protected, that they are to be recognized and protected in as powerfully as other fundamental rights, and that they are self-executing. There are at this point, though, 12 states in total, one of which is New York, that have been joining our Green Amendments for the Generations, our National Green Amendments movement. So actually we have proposals in 12 states, from West Coast to East Coast, and even in the middle. And I do have the language. I'm not going to go through it with you. We can certainly refer to it later if you'd like. But what I just want to tell you is every single state proposal is different. The language is different, and the language is different in order to serve the personality and the qualities and the goals of that particular state. No two modern day Green Amendments are alike. So that's important for you to know, but they all have the same basic fundamentals. Bill of Rights placement, clarity on the right, the environmental rights to be protected, that they are self-executing, and again, raising up environmental rights to that highest Bill of Rights legal and constitutional standing. Now, often we get asked the question, you know, well, gosh, isn't that language really broad? Clean water, clean air, healthful environment, what does that mean? Well, one of the most important things to recognize, right, is that all Bill of Rights, Declaration of Rights language is broad. It's intentionally broad. It's intentionally broad so that the people can both clearly express to their government officials those inalienable fundamental rights that they want protected from government infringement, but also allow the language to be able to be interpreted by the legislative branch, the executive branch, the judiciary, and the people to be able to cover the broad universe of elements that have to be covered by that particular provision, right? And the inalienable rights that they are referring to. So, you know, while we can say, well, what does clean water and clean air mean? You know, we can similarly ask, well, what is it to be free from excessive bails or fines? Like, what is an excessive bail or fine? What does it mean to get just compensation for the taking of property? Or what is the right to freely speak or to be free from unreasonable searches and seizures? These are all broad, this is all broad terminology, but it gets interpreted by the various branches of government in the context that it is clearly intending to achieve. So rather than focus on the precise words, clean water and clean air, what do they mean? We really need to focus on what's the process? by which they are going to be defined. And it's the same process that we have with other Bill of Rights provisions. The legislative and the executive branches are going to go first. They're going to seek to try to interpret and apply and protect the environmental rights that are enumerated in the language. And then once they do, whether it's through legislation, through regulation, through government actions of all kinds, right, it's then going to sort of come to the people, and the people are going to watch this interpretation in action. And if they don't agree with it, then yes, people are going to have the opportunity to go to the courts to get the judiciary involved in helping to further consider, refine, and define what these words mean in a particular context. And once the judiciary gets involved and we have their interpretation, we're going to have precedent that's going to help us refine that definition, and we'll go forth with that precedent. And then when the time comes where there has to be another legal action, we'll go through that process again. The same process that happens with free speech, freedom of religion, and more. When interpreting this terminology, the judiciary are going to use standard principles of constitutional interpretation, right? The judges in Pennsylvania and Montana are well equipped and have demonstrated that they're well equipped to interpret constitutional environmental rights language. There's no reason to believe that the New York judiciary and government officials are any less well equipped. And of course, the New York government officials have very effectively interpreted and applied the broad language in the other Bill of Rights provisions. So again, they've demonstrated they're well equipped to do it when it comes to the Bill of Rights section of the Constitution, and they'll be able to do it in the environmental context. But it is going to take time, right? We have had these other fundamental rights for, in some cases, hundreds of years. So we have a really good understanding of what they mean, but it takes time and it takes process. And so we're going to be at the beginning of that process here in the state of New York, and together we're going to be able to do that. I just want to highlight a couple of things about that interpretation. First off, when the judiciary is asked to get involved, we all know that the judiciary gives an appropriate level of deference to the legislative branch and the executive branch in how they interpret and apply laws. And the same thing will happen here. It's not going to be a rubber stamp, but there will be an appropriate level of deference if government officials have done their job of looking at the science, looking at the facts, looking at the impacts of the decisions that they are making before they make it. If they've gone through that informed decision-making process, then there is going to be an appropriate level of deference given to that. If, on the other hand, they didn't undertake a thoughtful process, that could be a reason why a judge says, hey, legislative branch, you need to go back and try again. And that would be appropriate because we want informed decision-making. The other thing just to note, right, is that having a Bill of Rights, protection for a fundamental right is not absolute. Right? It doesn't mean you have an absolute right to clean water and clean air. It simply means that there are appropriate procedures and limitations that are put in place by the Constitution in order to protect the environmental rights of the people from infringement, from overreach by government officials. But if at the end of the governing process, legislative, regulatory, otherwise, if government can demonstrate that, yes, there is in fact a clear infringement on environmental rights, but there's a compelling state interest that we can articulate. There has been an effort to minimize the level of infringement, the level of harm to the constitutional right, then that becomes a constitutional justification for whatever that action was. So those kinds of elements of constitutional and legal interpretation apply to other fundamental rights, they'll apply here. And I just wanted to give those two important examples. Oh, and then the other thing, just notably, in Pennsylvania and Montana, we have had a number of really successful cases. And so clarity is being brought to environmental rights amendment terminology. And so the state of New York will have the opportunity, even the luxury, of looking at what Pennsylvania and Montana have done to also help here identify what will be the appropriate precedents for the state of New York. And the other thing I was going to mention earlier, and then I said I'd mention later, and then I forgot it, but I'm going to mention it now, So, there had been the question about what does clean water or clean air mean? There's also the term healthful. And I did just want to highlight for you that in the legislative history and through, communications with the sponsoring legislators, very notably, the term healthful environment has two essential elements of it. One is the human health qualities of a clean and healthy environment. And the other is the health of the natural resources. Because of course, if we have healthy natural resources, that is of benefit to the people. So just wanted to highlight the fact that there are these two lenses for the term healthful. Again, that's in the legislative or in the constitutional history. Also, the question comes up when people are talking about this being an absolute right, which it is not. Expressing concerns about what will be the implications for economic development and job creation. And I just pulled one quote from a Pennsylvania Supreme Court case where Chief Justice Castile of the Pennsylvania Supreme Court, very, very conservative justice who actually was the author of a pivotal decision with regards to Pennsylvania's Green Amendment, goes to great pains to be very, very clear that the Green Amendment is not intended to, as he says, call for a stagnant landscape or the derailment of economic development, but that it is to ensure that economic development proceed in a way that is also mindful of, protectful of a sustainable environment, because a clean and healthy environment is essential for healthy people and a healthy economy. But just, one quote that I just wanted to highlight. There are numerous of them in all of the decisions where a constitutional environmental rights amendment has been brought to bear in Pennsylvania and Montana. The real goal of having the Green Amendment here in New York is the same as it is in Pennsylvania and Montana. The goal is to get better, more informed, more protective decision-making earlier on in the process, when we can actually have the best gains for environmental protection. It's much easier to prevent harm, right, than to try to remedy it after the fact when you're talking about the environment. So our goal is to advance the good in terms of government decision-making and prevent the bad. That's the goal. But it is true that when our government officials get it wrong, the New York Green Amendment will give people the opportunity to access the courts to try to vindicate their constitutional right to clean air and water and a healthful environment if they believe that government has gone too far or has not fulfilled their obligation to protect the environmental rights of the people. Now, this sort of raises one of the other concerns and challenges that we hear. We hear all the time that, oh my gosh, this environmental rights amendment is a make work project for lawyers, right? And we're going to have litigation all over the place and it's just going to be incredible. And that's really not the case. So first off, what I say to people is, really, the only kind of litigation when it comes to environmental protection that people should be concerned about is frivolous litigation. Litigation that does not have a solid, meaningful grounding in the law, in the facts, in the impacts for environmental protection. And of course, there are lots of prohibitions on frivolous litigation. If lawyers pursue frivolous litigation, there are all kinds of sanctions. They are financially in jeopardy, their jobs can be in jeopardy, and certainly their reputation can be in jeopardy. In Pennsylvania and Montana, we have seen 0 lawsuits, 0, can you see my 0, dismissed as frivolous if they raised a constitutional environmental rights argument. In fact, what we see in Pennsylvania and Montana, when you actually count up the cases where the constitutional environmental right has been raised, we're talking about 3 to 9 cases a year. And Katie will talk a little bit more about the context of those cases. The other question is, how is this environmental rights amendment really making a difference? Can you give some real world examples about how it's actually being used in Pennsylvania and Montana? And we can. There are a lot of good examples. Now, there are plenty of examples where the environmental rights claim has been raised and it's not succeeded. But I'm going to talk to you about the times where it's been raised and there has been success, because I feel like that's probably what you're more interested in. One of the things I do want to note is that the remedies that have been secured in Pennsylvania and Montana are equitable remedies. We're not talking about government paying out money damages to individuals who have been harmed by pollution and degradation. But what we are talking about, again, are equitable remedies. And here are some examples. So in the Commonwealth of Pennsylvania, there was a very pro-fracking law that was passed in 2012. It was actually the law that was noted in the introduction, the law where I, as a lead environmental plaintiff and the Delaware Riverkeeper Network, first raised the Environmental Rights Amendment in a way that the Pennsylvania Supreme Court utilized it in legally substantive and meaningful decision-making. It's sort of the first time it actually got used. And this law did things like put in place automatic waivers from environmental protection standards. It overrode, oh my gosh, I'm going too long or not? I'm looking at Katie. It overrode municipal zoning and mandated that drilling and fracking be allowed to happen, for example, in the heart of residential communities. And what the court said was that went too far, and those provisions are unconstitutional, and they were not allowed to be implemented. There was an effort to misappropriate environmental protection funds that had to go for natural resources development. The court said that was not appropriate, so those funds couldn't be utilized in that way. There's a situation where there's a very highly toxic site on the record. The government's on the record multiple times over, noting how toxic the site is, how dangerous it is for the environment, for people, how there's been a spreading pollution plume since the mid-1980s, and there are deep pocket responsible parties and laws that could secure the cleanup of the site. And Pennsylvania government has done nothing to clean it up, but did negotiate a deal with a developer to develop the site while it remained in this toxic condition. The litigation that's moving forward is saying that that failure to act and utilize the law could rise to the level of being a constitutional violation. In Montana, it's been used to challenge some very dangerous permitting for industrial gold mining. And there, long story short, the Environmental Rights Amendment was brought to bear and the permits were pulled back. And in another instance, the government was protected from having to enforce a contract that would have resulted in, that would have advanced test well drilling for drinking water and could have resulted in the contamination of an entire town's drinking water supply. Contract didn't have to be enforced, the damage was avoided. So if you want to learn more, there is a website, NYWEA.org, and hopefully I answered some of your questions. Oh.
Great, thank you, Maya. We're going to turn this over to Katie now. Thanks.
Oh, good. I took over the screen too early. Thank you so much, Maya. It gets me excited to hear you. And I want to thank NYWEA too. I think you really are providing a great public service here to try to educate people about this amendment. And I also have to take a moment to thank, I've had over the years numerous students at Pace Law School where I teach who've helped do research in support of this effort, including Ali Fausner and Patrick DeArmy, and my entire climate change law class this semester. So I would like to acknowledge their contributions to my research and thinking on this subject. So as Maya mentioned, I'm going to focus a little bit on some New York examples, but first I thought I would give you kind of a little bit of backstory about how I came to be involved in the effort or in thinking about constitutional environmental rights. And I will admit, I came up as a private practitioner and someone who I was, when I first heard about constitutional environmental rights, quite doubtful about the potential utility they could have. And it wasn't until I was asked at one point by the American Bar Association to give a year in review presentation. And as part of that, I was assigned to present the Robinson Township case to the American Bar Association, which I spent a lot of time with that decision. I highly recommend it to anyone. If you're going to read one decision about constitutional environmental rights, it's got some really wonderful analysis. And I think something that I would pull out about both the Montana example and the example from Robinson Township is I think what we're talking about here is maybe having some humility that despite this, the strength of our statutory protection and regulatory process, we nonetheless have situations where things go awry and there can be special interest capture. And I think actually in both of those cases, you had very strong special interests who had captured the legislative process in some way. And the courts, the environmental rights were able to serve as almost a pause, a timeout, a circuit breaker to correct for that public choice failure. So after I had done that, I was asked through my participation in the New York State Bar Association's Environmental and Energy Law section, which we love to call EELS, to lead a task force on the environmental aspects of the New York State Constitution. And that was a few years ago, and the process we were going through then is that New Yorkers were going to vote on whether to hold a constitutional convention to engage in a broad process to amend the Constitution. And what we were asked to look at is, if that were to happen, are there ways we would want to change the New York State Constitution with respect to the environment? I found that process absolutely fascinating because we ended up on that task force with a group of lifelong practitioners from upstate who've basically dedicated their careers to protecting the Adirondacks. And their entire focus in the course of that task force was to make sure that we didn't touch a hair on the head of Article 15 of the state constitution as it currently exists, because it has worked so spectacularly well as to help them protect the Adirondacks. I'm talking, of course, about the forever wild provisions in Article 15 of the New York State Constitution. As part of that task force, we also thought about, does it make sense to augment constitutional protections for the environment in the New York State Constitution? As part of that process, I spent a lot of time reading through state decisions about environmental rights, and reading through those state cases brought me to see some of the values of having kind of a judicial backstop, an environmental right, as an additional tool to improve our environmental protection. So in terms of thinking about, when I talk about gaps, or what are some of the ways that I think about an environmental amendment adding value, there are two that kind of surface to me as good examples. Oh, and before I move on further, if you're interested in the Montana gold mine case, I have to recommend this book, second only to Maya's book, The Green Amendment, if you're interested. But this, it really brings into light that the exemption from clean water laws that was adopted by the legislature there was a result of a large corporation and really in opposition to public will in Montana. But so if I'm thinking about having some humility about recognizing that there are some limits to the way our current suite of statutes and regulations protect human health and the environment, I think something we could probably, I think there are a lot of people here who have been environmental practitioners for a long time. For me, the advent of GIS mapping that revealed the extent of environmental injustice in the United States was really something new and eye-opening, and I think revealed a blind spot. And to some extent, that blind spot is embedded in our statutes. So if you look at the Clean Air Act, the entire city of New York is one air quality control region. And yes, we have some monitoring in the Bronx. But if you look at kind of the number of facilities, whether it's facilities that have toxic releases that are reporting under the toxic release inventory, or areas that are located where there's a lot of traffic, or where there are point source, or where there are permits being issued by the Clean Air Act, it's not a surprise if you look at the combined buffers around all of those emitting facilities, that you then see this hotspot of asthma in the Bronx. And so to my mind, this is an example of where we've surfaced these issues, but the folks who we have come to understand are experiencing these higher levels of pollution. Well, everybody's got permits. Everybody's got permits that are authorized under the law. Where applying the law, having an additional tool that would help to address this, I think could be very helpful. And the other area, and I venture a lot of you on this webinar know much more about this than I do, but where I think we've recognized a kind of, I don't want to call it a blind spot, but someplace where we've had some regulatory pathologies show up in terms of the timeliness with which we've addressed things would be with respect to emerging contaminants in drinking water. You know, and I remember when there was a newspaper article when the legislature was considering the Green Amendment, where the Director of Government Affairs for the Business Council was quoted saying that a Green Amendment was unneeded because residents struggling with contamination of their drinking water supplies, like those in Hoosick Falls, quote, already have multiple means of legal resource. And I have to tell you, I get stuck on that, because when I think about the folks in Hoosick Falls who found PFAS in their drinking water, first of all, I'm not sure there is legal resource when you've already been exposed and been exposed for as long as many people have already been exposed to emerging contaminants that were under study for decades. And second, there was no legal resource under the statutes at the time. Why? Because it just wasn't regulated, right? We all know that it was languishing as a contaminant chemical subject to study after study after study. And so if what he's talking about there by legal resource is a common law action for damages, first of all, I'm not sure that's ever really recourse. I think we all, those of us who are attorneys on the phone, understand the difficulties showing causation, and you're never really going to get compensated for that period of dread when you don't know if a potential health issue is going to manifest. And so what I want to suggest here is that I think one of the hardest things about understanding the value of a constitutional environmental right is that what we have to do is ask a counterfactual inquiry. So rewind your head to your torts class if you ever took a tort class. But what a counterfactual inquiry asks is how would things have been different if we changed one fact way back when? And I would submit to you, if you look at the history of some of these emerging contaminants, I would characterize this as what happened with respect to PFAS, the extent of contamination, how long it kind of languished in regulatory purgatory, not really being sufficiently studied in a prompt way. It has to do with a lot of things. It has to do, of course, with the fact that we had some bad corporate actors who violated the Toxic Substances Control Act by not sharing information about the health effects of the chemical, who stymied regulators every step of the way. I think the book Exposure is a great kind of documentation of that. What I think we have to imagine is, could things have been different had New York had a right to clean water at the relevant times? And I submit, I think it's entirely possible that we might have avoided the extent or duration of the contamination if we had regulators who'd been empowered, interest groups who'd been empowered to advert to that right to clean water, such that the answer wouldn't have just been, well, it's not regulated under the Safe Drinking Water Act. And something that brought this really to the fore for me is at one point, probably about 5 years ago, I got a call from an elected official in New York who said, hey, they just found this chemical in my constituents' drinking water. And it was 1,4-dioxane. And he said, what's going on here? Can you tell me about it? And so I just said to him, I said, hey, here's the deal. They're finding it because they're monitoring for it, because it's a contaminant chemical under the Safe Drinking Water Act. But there's not, and there are these studies that suggest cause for concern, and probably I wouldn't want to be drinking it on a regular basis, but there's no current, you have to wait for the process, under the law. And of course, at this point, how long are you waiting? We're talking decades and decades. And I get there's a problem there with budgets and resources and all of that. But I submit to you that if we had had a right to a healthy environment, it's entirely possible we would have been able to avoid some of this regulatory regulatory pathology. So I also want to talk a little bit about the choice of language. I know you had a question about the simple language, and here's the Pennsylvania language again, here's the Montana language again. I just wanted to point out to you, there's even more similarity between the Montana language and New York's in the following way, because New York actually, of course, already has an Article 15 to the environment. So the parallel to Montana is quite clear. I would submit to you that the most important part about this language is not what it says, but where it is. The fact that it's located in the Bill of Rights. Because frankly, we already have this language in Article 15. It hasn't done us a whit of good because it hasn't been understood to be self-executing. Putting the language in the Bill of Rights is what is going to make it effective. So when we were on my task force for the Bar Association, we thought kind of public trust framing would be kind of the best. We kind of landed on the side of public trust framing for the amendment. What may interest you is why we did that. So it is surprising to me now to hear that the criticism of this language is that it's going to lead to this incredible judicial overreach and explosion of litigation. Our determination from looking at this is that the broader the language is, the more judicial deference courts tend to show to legislatures. So our concern, and the reason that we were interested in proposing the public trust language, was to embolden courts to be more active and to actually take the amendment out for a spin in a more robust way. And I would flag for you that I think the real risk here with this language is not that courts will run riot with it, but that they will be too timid because they won't feel they have enough direction. And if you look at the experience in New York with respect to the way that courts have interpreted, enforced, and applied other constitutional rights, for example, with respect to the constitutional requirement that the state provide aid, care, and support of the needy, the courts give the legislature a lot of autonomy to determine the adequacy and the amount of aid. I also think, to second what Maya said, having language that is broad, simple, and clear is consistent with other Bill of Rights provisions, and is also, the beauty of it is in its flexibility to incorporate kind of a range of issues and scientific developments. And I will say, we went back and forth on the task force about this, because the folks who are enforcing the Forever Wild provision, we understood the clearer it is, the easier your task getting courts to help you enforce it is going to be. But the trade-off there is the more specific you make it, the narrower it tends to get. And so I would submit to you the beauty of this language is its location. So what I want to dive into now, and I'm sorry, my clock is not up. I'll try to go fast, but answer some, I'm going out on a limb. So I'm going to make some forecasting. I think if you're going to support the Green Amendment, you have to accept and understand that there is some uncertainty about exactly the way it will be interpreted and applied. I think that uncertainty is within a range that's entirely acceptable. And that the benefits far outweigh those risks. So the first question that comes up is this in fact self-executing? So part of what in the task force, we kind of said, you should outright say it's self-executing, because we didn't want there to be any doubt. This is an excerpt from the decision that looked at the current language in Article 15 of the conservation provisions of the New York State Constitution and held that they were not self-executing. So after having looked at this, I'm going to tell you, I think I think that the Green Amendment would be interpreted to be self-executing. In New York, constitutional provisions are presumed to be self-executing, and other broad rights in Article 1 of the New York State Constitution has been held to be self-executing. So I think the answer here is yes, even though I would have liked it to be expressed. I think we still get there. Next question that comes up, is this enforceable against private parties? I think the answer here is probably no. And what I put up for you is the difference between provisions of the Bill of Rights that have held to be enforceable against private parties versus those that have not. And I think you'll see the Green Amendment. So where our equal protection provision expressly says that it applies to any other person, any firm, corporation, institute, state, agency, subdivision of the state. Whereas Article 1, Section 3 and Article 1, Section 8, that like the Green Amendment, don't include that type of language. Courts have held do not apply to private parties and only apply to the state. Now, I will flag here, I know that for many of you who are advising or involved with water groups in New York. So in New York, my understanding is water is provided sometimes by private companies who are regulated by a public service commission, sometimes by public benefit corporations. We have wastewater treatment plants that are oftentimes operated by municipalities. So there's this kind of this quasi-governmental nature of a lot of this water provision and water work. And I can't tell you right now which side of that public-private divide each of those different entities might be deemed to fall under. So I would say not applicable against private parties. That then raises the question of would a specific entity be considered public or private, for these purposes? And the next question comes up, does it support a damages remedy? I can't tell you absolutely not, but I can tell you I would be pretty gobsmacked. So there are some really limited circumstances in which New York has recognized what's called a constitutional tort, so allowed damages claims for violation of the Constitution. I will flag this. So this is the relevant language, how the test is described in New York. This decision in Brown has since been applied with significant restraint, and even in Brown, the Court of Appeals emphasized the limited nature of its decisions, characterizing its holding as recognizing a narrow remedy that was designed to provide protection against official misconduct. So is there a set of facts involving official misconduct where the amendment, the court might recognize a constitutional tort? Maybe. I tend to think it's likely to come out the other way. But again, lots of caveats here. This is my best reading of the relevant case law. And there's another question you posed was related to, will there be new claims available, or how will this change how we litigate under the claims as citizen suits are litigated? And so what I want to, I'll tell you how I think of it. So first of all, I do think there are new claims. You would have no basis to challenge a statute on its face as unconstitutional because it doesn't adequately protect your health, water, or air, right? Now you could. So I could imagine a declaratory action seeking a declaration that a statute or an ordinance violates these provisions of the Constitution. How common are those kinds of claims? Not particularly, not particularly common, and likely an uphill battle. The other type of new claim, I wouldn't even characterize that. The other way I would expect you would likely see constitutional claims raised would be appurtenant to existing citizen suits under existing statutes. So in addition to saying, oh, there's a violation here of these requirements of the regulations or permits, etc. And by the way, it also violates our right to a healthy environment, right? So that kind of, I think you're liable to see those kind of appurtenant claims under kind of the use of existing citizen suit provisions and actions that would have been brought anyway. The harder question to me is, well, is it possible that you could bring a standalone claim directly under the Constitution without referencing you violated a permit, you violated a statute, kind of some kind of cause of action directly under the Constitution to try to enjoin conduct alleged to violate these rights? And I will flag for you, sometimes constitutional environmental rights provisions explicitly seem to provide for that kind of cause of action. So for example, look at Article 15 in New York, which is, by the way, because the provisions in Article 15 have been deemed not to be self-executing. I think there are only 3 notes of decision under this, so it's barely ever raised. But for example, in Hawaii, there's language in there related to their environmental rights that says any person may enforce this right against any party, public or private, through appropriate legal proceedings. There's similar language in Illinois. Our Green Amendment is silent, right? Which would seem to suggest that maybe there's not a private cause of action there. On the other hand, it's quite clear that citizens can sue to enjoin government conduct that violates the right to free speech, the free exercise of religion, etc. So I'm going to tell you, it doesn't seem entirely clear to me. But what I would end with here is to say, I do think, with respect to all of these claims, to underscore Maya's point about deference, after a period of judicial interpretation, I think we are likely to see the development of a rubric through which the court can clearly just dismiss a lot of claims, come up with a rubric for here's what can count and here's how we assess it, and then we all get used to that and move forward. So what I'll close with, and I know we've kind of gone, oh my gosh, I'm just gonna close. I didn't realize how late it was, and I'm sorry we went on so long.
You're doing great. We have until 5 o'clock, so we've got some time here. If there was any last remark before we jump into questions, you're welcome to make it.
Well, okay, then I'm going to give my final thought, which is when I think about what is, the real value here, and I talk about gaps, I think the single biggest gap we have is with respect to climate change. And some of the more sobering things I've seen, I started teaching a seminar on the law of climate change in 2007. And for the first 5 years I taught the class, every single year I taught it, I thought there would be a federal statute that I'd be teaching the next year. And I read all of the academic literature about how hard it would be for our political process to come to bear in a meaningful way on climate change. And the fact that we still don't have a federal climate framework law in the United States is disturbing in particular, since it's not just the adoption of a law. When it comes to mitigating climate change, we're going to need sustained political will and sustained action to actually implement it. And so if there is a moment when we need every tool in our toolkit and where we need to make sure we can't afford regulatory pathologies, we can't afford to have blind spots when it comes to transitioning with respect to climate change. And I think the last point I would have is that when I think about, and when I talk to people who are not lawyers about this, they just assume they have a right to clean water. They assume they have a right to a healthful environment. They're kind of shocked to discover they don't. And actually, there are arguments that are made that we already have these rights, right? So if you look at the Juliana case, the argument, one of the chief arguments there was actually there is a pre-constitutional right to our sovereigns can't destroy the conditions that we need to survive, right? This idea that there is this public trust and it's pre-constitutional. And so maybe the reason it's not in the Constitution is because never occurred to us it had to be, right? So in some sense, this is not radical. We have a lot of, 150 countries have environmental rights provisions in their constitutions. And when you think about it the other way, if we had a right to a healthful environment in our Constitution and we were asking people to take it out, it would, I can't imagine it ever having traction. So at the end of the day, I think that the concerns that are raised about a constitutional rights amendment transferring policymaking authority from the legislature to the courts is overblown. And how can we know that? We can know that for two reasons. First, we can look to the experience in other states that have these rights where that just hasn't happened. These rights have come to bear in unusual circumstances as a judicial backstop. And the second way I think we can know that is to look at New York's own experience in implementing and interpreting its constitution. So to just hold that up as, oh my gosh, the sky is falling, there's going to be an incredible transfer of policymaking authority to judiciary, I don't think that holds up to much scrutiny. The second concern that's raised, that we're going to have a proliferation of litigation, I do think there's going to be a period when we will have cases being brought to develop the doctrinal approach to interpretation of the constitutional amendment. But again, experience would suggest that that will settle out. And at the end of the day, what we'll be left with is a complementary piece to our environmental protections that can frankly represent some humility about, as good as our statutes can be, as hard as we may work to regulate, it is beneficial to have an additional way that citizens and environmental groups and others can lean into the process, particularly when it goes awry.
Thank you. Well, thank you so much. I really appreciate it. Thank you, Maya van Rossum and Katie Kuh. Really great presentations. We have some questions raised by our audience, and I invite folks to please add your questions to the Q&A feature in the bottom, if you can. And I will also note that Libby Ford and Pam Alardo may also have a few questions that they may be adding in for us. Libby Ford from Nixon Peabody and Pam Alardo from DEP.
Okay, and let's start with the panelist discussion. Katie, did I hear you right that in terms of public water and wastewater authorities, you're not sure where the courts would come down in terms of whether this amendment would apply, whether they could be a focus of a claim directly rather than all claims having to go against the state?
So I think what you're hearing me say is, yeah, I don't know. And I haven't looked at that. My guess is those of you who do work and represent these folks have a better sense of how they're treated, what their actual legal status is. What I feel comfortable telling you is that there will be that public-private divide. In terms of which side of the line specific entities would fall on, I'm not as comfortable with.
Can I, it's okay if I speak up as one of the featured panelists who get to talk? This is Pam Alardo with the DEP. First, I just want to thank the two presenters. I swear in that short period of time, I really learned a lot and it was pretty refreshing. Self-executing is now a nice term that I will add to my personal lexicon for a bit. But I gotta, when you talk about people who may have concerns about this type of amendment, I think you hit the nail on the head when you talked about uncertainty and sort of perhaps a window of uncertainty that makes the near future at least unpredictable. And there's a lot of concern with that, particularly when you're talking about very restrictive budgetary constraints that we're up against right now and how that might impact our ability just to serve our basic, day-to-day services. So you do recognize that as a concern, and that's great. But I also want to say that I liked your exposure about the example you gave on the fracking, and I think you used the term legislative corruption. And if in fact a legislature steps over a line in terms of what's a basic right, there is that ability to challenge. I think there's some common ground between people who might be providers of services and people who care about who want to pursue this this type of approach. I have to say some of the sometimes the language gets a little funky, for lack of a better word. And I think when people hear a right to something, when it comes to the right to vote, yes, the right to vote, you should not have to pay for the right to vote. You have an unalienable right to vote, the right to free speech. Although you can argue people with money have more free speech than those without because they can buy newspapers, et cetera. But you think of a right being not financially burdensome to you. And I have even heard people, without thinking too deeply, that water is a right it should be free. And the type of public investments it takes to deliver clean water and to treat dirty water, to provide a clean environment so that people can enjoy beaches and not get sick, is a very expensive prospect. And it does create a lot of, it does need a lot of funds. Now, whether they come from property taxes or the federal government or a water and sewer rate, for example, it's definitely not free. So there is, that's the kind of concern you'll hear from like, our side. And I do believe there's common ground. And I think there's there's some light, and there's some of the things you've talked about are kind of refreshing in my mind and definitely educational. So yeah, can you just talk about like those couple things, like the uncertainty? I think you covered really well, but the term right and what that means to people, I think adds another layer of uncertainty and really concern for the ability to protect the public in terms of the funds we're spending, and it's their funds. So I'll stop at that. Thank you.
So I'll jump in a little bit, and then Maya, I think you had some thoughts on this too. And I apologize. We meant to incorporate an answer to that question about could people come and say, use this right to say we're entitled to free water. And I was really surprised to hear that question. Mostly it just never occurred to me. And one point I would make is that regardless of what people believe their rights to be, what their rights turn out to be will ultimately be evaluated by courts. And they'll be looking to the text, how they can be some of the legislative history accompanying it. And I was curious, like, why has this never occurred to me that the right would be understood that way? And I think part of it was because if you go back and you look at some of the legislative history to the amendment. I'm trying to find that. I know I printed out the language here somewhere. To my mind, it seems oriented toward ambient environmental conditions. And so the purpose of the bill is described as to protect public health and the environment by ensuring clean air and water. So ensuring clean air and water, to my mind, speaks to the ambient conditions. I think the other piece you're surfacing, which is a complex one, is that most of the rights that we identify in the Bill of Rights are negative rights. They're constraints on what the government cannot do. And describing the right in the way that you just did as compelling that the state provide clean water would be an affirmative spin on it. And it's not, I think the other answer I would give is that other states, this has just never come up or never been applied in other states that have similar language. I would suspect that part of the reason why is first that these rights are anchored in and understood to be anchored in ambient environmental conditions. But second, that courts are much more comfortable applying them in that negative sense, right? So constraining government action as opposed to putting affirmative obligations on government. And I'm interested to hear, I am very sensitive to the resource issue. And part of when I think about the emerging contaminants issue, it's not that EPA, well, I don't know. There definitely are resource constraints, right? We'd love to know everything about every chemical and know they're perfectly safe, right? And you just can't. Wouldn't it be great if a citizen could force the legislature to give the regulators the money they need to do the study they need by saying, hey, enough studies have burbled up to the top here that this is now worrisome enough that you need to prioritize it. And so in some sense, I could imagine it being a prod to devote resources where they're needed and just involving the public in part of that determination about where are the resources needed.
Taking that a step,
Yeah,
taking Pam's
can
question.
I add to that, Libby, just before you before you jump in. So one of the things, so the Robinson Township case is actually the Robinson Township Delaware Riverkeeper Network case. It always galls me a little bit that the township gets credit for our legal arguments that won the day. But that being aside, that is that just so you know, the Act 13 case that I talked about, the Robinson Township Delaware Riverkeeper Network case that Katie talks about, are one and the same. And one of the things that was so powerful and important about the interpretation that the conservative Pennsylvania Supreme Court put forth was they really were making clear that the Environmental Rights Amendment needs to be interpreted and treated in the same way as those other fundamental rights. And one of the most important, self-executing, is a really important interpretation and value. And just for the person in the chat, right, meaning that the amendment, the language has legal enforceable strength on its own. You don't have to find a law that is implementing it in order to give it legal life. And so that's why when you have a gap in the law, like if you're talking about PFAS, for example, the constitutional environmental right can be relied upon in the absence of law. But one of the things that Chief Justice Castile and the plurality made very, very clear, which was later solidified in a follow-up decision 2 years later, was that the Environmental Rights Amendment is in fact a limitation on government authority, right? Preventing infringement on the right. And so I just wanted to emphasize that aspect of Katie's answer. So when you think about it in terms of the contaminated water context, it's not going to be about whether or not people have to pay for the service to clean up that water or to get it into their home. It's going to be looking at where is the government action where there was, they are advancing, for example, they are providing a permit for an industrial operation that's going to release contaminants that are going to result in serious contamination to the river, to the stream, that might ultimately end up in somebody's house. That is allowing that or permitting that contamination to happen, and then taking a look at that. You might have, though, a situation like a PFAS situation where you have sort of the failure of government to act. So when you're talking about PFAS, had there been a Green Amendment at the time when the companies started using these dangerous contaminants, there could have been an argument that the government needed to act to prevent the use of these contaminants before they, until after they had been assessed and considered, that there had actually been a mindful decision making, and that later on, when you actually had the contaminants in the environment, that the failure of government to put in place standards, protections to protect people's clean water, that failure to act is where the government comes in, and you have a constitutional problem. But I would agree with Katie. I think that the idea that there's going to be an expectation that people get free water all over the place and they don't have to pay for fair and appropriate services is unlikely. And in fact, if you think about other constitutional rights, you have to pay a fee to get a marriage license, right? You have to, there are legal costs associated with the implementation of the courts, right? And people benefiting from their civil rights. If you want to gamble, right, you got to put forth your money in order to gamble. So it's not that every right that's protected in the Bill of Rights is you get it free of any cost. There are in fact costs associated. It just varies depending upon the right. So I do think that it's unlikely that we're going to have that kind of, unlikely to have a claim like that be successful. I think it's probably unlikely that somebody would bring that claim as well and have it get very far if they did.
Thank you. But kind of turning Pam's question around a little bit, what about, municipalities and the like who are supplying clean drinking water? Could this, but if people aren't paying their bills, eventually the municipalities have the right to, turn them off, to shut off service. If you've got a right to clean water, can that be the basis to keep municipalities from shutting off services? Or in another example, to force municipalities to extend wastewater services, sewers, to areas that haven't been sewered yet, in order to protect that right to clean water.
So I think, again, just emphasizing the aspect of the answer that Katie put forth is that I think that we really are talking about what is happening, in terms of ambient conditions, in terms of the quality of the water. We're not talking about the service of delivering that water to people's homes. So I don't have an expectation that that's going to be raised. And in terms of wastewater too, right? We're talking about an entirely different concept. Where wastewater, the treatment of people's water is in fact a service of I was going to use a 4-letter word, but I won't, coming out of people's homes, right? And that is really fundamentally different than giving people the right, protecting the clean water, the clean air that is out in the community to ensure that they have the benefits of a clean, healthy, and healthful environment and the natural resources that are associated. I think that these are fundamentally, I think we're talking about apples and oranges here. But there is the reality, that some of it, people are going to be thinking about this and thinking about it deeply. But I don't think that it's likely that kind of, you have to give me everything for free in order to enjoy my world and to benefit from access to beautiful forests and recreation areas and other natural resources, that the freeness of it is not the focus of the Constitution. It's the right to clean water, not the right to free water.
And Libby, if I had to put kind of a fine point on it, I can't sit here and tell you that there isn't a universe in which potentially it's given that interpretation. I can tell you that of the various questions that I've looked at in terms of how this would be interpreted and applied, that's one that would leave me, I would be really surprised. I would be frankly gobsmacked. And the reasons I would give you for that are, first, these are courts that are engaging in constitutional interpretation. I see nothing in the relevant kind of typical interpretation tools that they would use. So looking at public trust doctrine, looking at the constitutional kind of the statement of legislative purpose, looking at the terms that are used. It's not a right to water, it's a right to clean water. I think all of that, to my mind, points in a strong interpretive direction. And then I would add as fourth to that, the fact that courts tend to be, in interpreting these constitutional provisions, extremely deferential and wary to impose affirmative duties on the government in that way. And so all of those things are why it never occurred to me until I got your questions. And I can't sit here and tell you it couldn't happen. I can tell you of the various kind of concerns, probably it just isn't, it's not, I don't see it as it wouldn't keep me up at night.
And I would just like to offer sort of a different lens, a different look into this as well from the municipal perspective, is really looking at all of the important values and protections that municipalities get out of this, right? So if you do have a municipality that is responsible for providing water services or other services, right, it does cost. It can be very costly to clean contaminants out of the water. And so, from a water purveyor's perspective, municipality or otherwise, to the extent that they too will be able to use this constitutional right to defend their right to clean water and ensure that state government and other government entities are protecting the quality of the water that they are receiving and benefiting from as government entities, as communities, is powerful and important. And I will just refer you back to that very last case that I quickly threw out there. I mean, we were talking about an entire town's drinking water supply that was going to be contaminated by toxic contamination because of some activities happening upstream. And there, the Environmental Rights Amendment was really used in a very powerful way to say that that contamination to entire town's drinking water supply, to the extent that the government has a hand in that would be a violation of their duty to protect the environmental rights of the people. And there are numerous examples of that in that Act 13 case, the Robinson Township Delaware Riverkeeper Network case. We had 7 towns that joined us in that litigation. So we were the only environmental organization And we were advancing primarily the environmental rights claim. But those 7 towns joined us in that legal action. They also had their own legal claims because they were very, very concerned that government had sort of overtaken, had usurped, had displaced their zoning authority in the context of the industrial fracking operations. And they were able to use that environmental rights amendment to protect that important local authority that belonged to them. So there are a lot of examples. There's another case where the Pennsylvania Public Utility Commission, where the administrative law judge recommended against the approval of 2 major power line transmission lines that had been proposed, in part because of a failure to demonstrate need and to complement the level of environmental harm that was going to result if these power lines had been allowed to build. And amongst the arguments that have been brought forth, there were by a school district and real serious concerns about implications for school property. Okay, that's not a municipality, that's a school district, it's a little bit different. But there too, you have another government entity, and there were others. There were farmers and property owners of all kinds that were going to be impacted. Historic resources essential, natural resources and historic sites is essential for economic development. But there are so many ways that the local, more localized aspects, arms of government get power and strength and benefit from having an environmental rights amendment, a green amendment, that I think it's really worth focusing on that. And similarly, you're going to hear from the business folks. There's tremendous value for them as well. I mentioned farmers or organic farmers. They're business people, right? And there are numerous situations where farmers have been benefited by the environmental protections that come from an environmental rights amendment, and in the PFAS context could have been benefited by the prevention of harm. In that drinking water case, it was a business whose neck was literally on the chopping block. If they had been forced to go through with this contract, there would have been a whole slurry of economic costs that fell down upon them. So there are a lot of different ways that this will play out, but I think it would be a mistake for people to really try to just let me think of all the ways this is going to hurt me, rather than let me think of all the ways that this is going to help me. And in terms of economic development and business operations, I would submit to you that there's always a way to do it that's more environmentally protective and beneficial. And I would submit to you that businesses of all kinds get tremendous value, whether it's direct monies from a developer who's going to have, increased property values and be able to more quickly sell environmentally friendly development projects, to businesses that need healthy workers who aren't going to be suffering from, air-caused asthma attacks or heart attacks. We all have benefits from from a clean and healthy environment. And so I think that really understanding the many powerful ways that this comes to bear to help advance our society as a whole is really a worthwhile shift in the lens people are trying to look at this.
So kind of to pick up on that, I noticed across the country, there's a lot of drinking water authorities, cities, and even some states now suing manufacturers of PFAS and PFOA. Do you think having a green amendment would help in those court cases in terms of trying to get the manufacturers of these forever chemicals to contribute toward remediating problems?
So I'm actually going to segue that into answering a question that's in the chat, because I think it answers that. I don't see the Green Amendment as being directly relevant to the outcome in common law tort suits. I also don't think that the remedies available in the common law tort suits are entirely satisfactory. And the question in the chat was, would you explain how the amendment would speed up the process of addressing a contaminant being detected in air water when the science has not yet determined whether it's harmful or not? And I think this relates also to a question you sent us, which was, how would this affect the processes, if at all, that we use to set water quality standards and address emerging contaminants? I think my answer to you, probably not going to change the processes, except give them a kick in the pants when they need it. And I would say with the vast majority of emerging chemicals, they move their way through the process, and that's fine. If you look at what happened with PFAS, I think there's a lot there to say. Part of the reason we didn't have an answer to the scientific question is because we had a heck of a lot of corporate misconduct at suppressing information over a very long period of time that prevented us from developing that information. And so how do I think that having an amendment could have moved things along? I think the answer is it could have pushed regulators to put it to the top of the list earlier in light of concerns that were becoming clearer and clearer. And so to give citizens some weight to say, I understand you're still studying this, you can't set an exact MCL at this point, but maybe we shouldn't be being exposed right now. And to really, sometimes the process has dysfunction. And to my mind, when I look at what happened with PFAS, there was a lot of dysfunction, and there was a fair amount of, the process didn't work as fast or as well as it should have. And I think a green amendment could have been helpful to push it to be better and to respond faster.
No, the other thing I just want to add to that is one of the many values that comes from the Bill of Rights placement is really the obligation of government to engage in that informed decision making. In part, what a green amendment does in the environmental context is bring the precautionary principle to life. And so if you have a situation where you have a contaminant that's being developed and that industry wants to use, and the science is not yet ripe to demonstrate what are going to be the implications of that new chemical, well, the answer is in the absence of a green amendment might be, sure, we don't have a regulation or law, go forth and use it and let's see what happens. In the green amendment context, what you really can bring to bear on this is that there really is a duty on government officials to engage in informed decision-making, to ensure that their actions and activities or their failure to act in that kind of context, right? Like if they're engaged in permitting, their failure to just totally ignore everything, that actually is a constitutional violation, that there is a duty to engage in informed decision-making. And so if you don't have the information, you must go forth and get it before you issue the permits and the approvals that allow it to happen, or you sit back and sit on your hands and do nothing. And this informed decision-making obligation has been demonstrated in the litigation. And so in one of the industrial gold mining cases in Montana that I talked about, one of the fundamental critical failures with regards to the permit that had been issued for the operation was that the government had not done the job of looking at the science and looking at the impacts and looking at the environmental and community ramifications. That failure to engage in informed decision-making, in part, resulted in the decision that resulted in the rescission of the permit. Now that permit, and one of these cases just happened recently, the final decision came down at the end of 2020. Now, it is very possible that the gold mining operation will come forth and they will bring forth all the relevant analysis and information, and the government will in fact do its due diligence and come to an informed determination that there will not be a violation of the constitutional right, and then the permit will be issued. But you can't just throw up your hands and say, well, I checked all the boxes, I think it's going to be okay. And then let's hope for the best. That doesn't work. We also have in Pennsylvania, one of our cases was a situation where it was the spreading of sewage sludge, and a permit had been issued to spread sewage sludge right at the top of an exceptional value stream, and there were residential communities all around. And this sludge was of a class that it had very significant contaminants. And one of the things that came forth in our legal action was that the permit was issued, again, without the agency looking at the science or the impacts. And so the constitutional problem was the failure to engage in informed decision-making and simply to rubber stamp, right? So that's how I think, you know, the question in the chat, that's how we help stave off problems when the science isn't yet there. We say we need to get the science first, and then we'll make a decision.
So this is Pam. I know we're going to.
Oh, yeah.
I know we're going to close in 1 minute, but I just got to say, it's a great conversation, but I kind of take offense to the regulators throwing up their hands, doing nothing, being useless, because that is not the way it operates. The state regulating community who regulates the regulated, that is me, I used to be a regulator, are very conscientious people. They drive to the science. There is unknowns. And I think one of the worries that I have is you're never going to have enough science. There's never going to be zero risk. And we do have to rely on the scientists using the best professional judgment to protect public health. And when you go through some of the, if you're going to set a PFAS limit, there's a whole list of studies and it takes years. And yes, we get to a point where we could agree on it. Absent that, we have to go forward with pursuing environmental best professional judgments and best science as we move along. So I'm becoming a little concerned about some of the examples that were just brought up. But I do think we could work together and not make assumptions about each other's opinions or positions, and try and come up with something, a way to implement this and get people on board. I look forward to future conversations about that. Thanks.
The thing is these examples, we're not making assumptions about people's intentions and not even assuming bad intentions, but they are the reality of what happened. Those are the facts of those cases. And in part of the problem is that there were not regulations in place that the regulators could rely upon to, particularly in the PFAS and the emerging chemicals scenario, that the legislation and the regulations aren't there for those regulators who want to do better. Or if you have an environmental justice community and there's a new proposed permit, people are not saying that there's ill will in every instance where you're increasingly having this disproportionate impact on communities, although it does happen. And I don't think that it's fair to deny that it does happen. But often too, if the laws aren't strong enough, we often see frustrated regulators which would like to have the tool to do better, to do more. And a green amendment gives them that tool. But I think I am struck that you would be offended by nobody is casting aspersions on anybody or saying that anybody is of ill will, but there is the reality that our current system of laws are not providing the level of protection that people and communities and businesses need for any number of reasons. It might be how they're written, it might be resources, any number of reasons. And so I think, having this powerful tool that can benefit all of us in a positive way is important. And having this powerful tool in those situations, in the pro-fracking situation, that law that was passed was written by the industry and passed by the legislature, and there was a lot of evidence about the lobbying contributions that were behind it. So those things do happen, and giving the people the power, giving that, and that's what a green amendment does, is it gives the power of environmental protection back to the people and ensures that the people are making clear to the government, these are the rules of the road. In our constitutional contract with you, we have a lot of rights that we are protecting from infringement. And now we are adding the environment to that. And that is appropriate. And as we can see by what's happening on the ground, it's necessary.
Well, I want to say thank you so much. I know this is a conversation that we could have for many more days to come, and I do hope the conversation continues. Thank you so much to our speakers and to our panelists and to those who have asked questions in the chat. I think all of those questions were answered, so I appreciate that. I'm going to turn it over to our President, Lauren Livermore, to give some final thoughts.
Great. Thank you so much, Sarah. And yeah, this has been such great conversation. I really appreciate Katie and Maya giving their presentations and engaging in discussion with us today. I did want to give a little NYWEA update. If you're interested in actually some of the issues that we've been talking about, we have a joint legislative dialogue that is taking place next Thursday on May 6th. where we'll actually be talking about PFOA, PFOS, emerging contaminants, residuals, nutrients, and the revised lead and copper rule. We'll also be talking about funding priorities, water affordability, and COVID-19 impacts. And it's actually a joint event with the New York section of AWWA and the New York Rural Water Association. So, you know, we can talk a little bit more about some of these legislative issues. So again, thank you everyone so much. I really appreciate all of the attendees and all of the help with moderating this session. We look forward to voting at the end of the year. I appreciate it.
Thank you, everyone, and thank you, NYWEA, for your great works. And thank you, Katie, for your great partnership in the presentation.
Thanks, everyone. Take care.